Today we are going to talk about infringement and passing off of trademark in India. Trademark infringement दिया गया है under Section 29 of the Trademark Act of 1999. It basically means unauthorized use of trademark that is identical or deceptively similar to a registered trademark. तो अगर सिंपल लैंग्वेज में देखें तो आपने अपने ट्रेडमार्क को रजिस्टर कराया अंडर द एक्ट और इसलिए आपके पास कुछ एक्सक्लूसिव राइट्स हैं कि वो ट्रेडमार्क आप यूज़ कर सकते हैं। लेकिन अगर कोई थर्ड पार्टी आपके उस ट्रेडमार्क को यूज़ करे विच इज़ आइदर डिसेप्टिवली सिमिलर और आइडेंटिकल टू योर ट्रेडमार्क, तो आपका जो एक्सक्लूसिव राइट है वो इन्फ्रिंज हो रहा है। क्योंकि आपका राइट इन्फ्रिंज हो रहा है तो यू कैन टेक एक्शन अंडर द एक्ट। लेट्स सी व्हाट सेक्शन 29 सेज। Infringement of registered trademark. A registered trademark is infringed by a person who, not being a registered proprietor or a person using by way of permitted use, uses in the course of trade a mark which is identical with or deceptively similar to the trademark in relation to goods or services in respect of which the trademark is registered, and in such manner as to render the use of the mark likely to be taken as being used as a trademark. The important thing to note here is that the trademark in relation to goods or services in respect of which the trademark is registered. तो यहाँ पे बात हो रही है about the नीस एग्रीमेंट। नीस एग्रीमेंट में दिस इज अ क्लासिफिकेशन ऑफ गुड्स एंड सर्विसेज। तो जिस क्लासिफिकेशन के अंडर आपने अपने गुड्स या सर्विसेज को रजिस्टर कराया है, तो कोई थर्ड पर्सन उन्हीं गुड्स और सर्विसेज के रिलेशन में आपका मार्क यूज कर रहा है, तो वो आपके राइट को इन्फ्रिंज कर रहा है। Clause 2 says a registered trademark is infringed by a person who, not being a registered proprietor or a person using by way of permitted use, uses in the course of trade a mark which, because of its identity with the registered trademark and the similarity of the goods or services covered by such registered trademark, or its similarity to the registered trademark and the identity or similarity of the goods. Its third is its identity with the registered trademark and the identity of goods or services covered by such registered trademark is likely to cause confusion on the part of the public or which is likely to have an association with the registered trademark. तो यहाँ पे तीन कैटेगरीज दी गई हैं। फर्स्ट वन इज जहाँ पे इट इज the trademark is identical to the registered trademark being used and the goods or services are also similar. Then second is it is similar to the registered trademark and the goods or services are identical or similar. And the third category, the mark being used is identical to the registered trademark and the goods or services are also identical. If any of these is happening and it is likely to cause confusion on the part of the public, or which is likely to have an association with the registered trademark, then your trademark is being infringed under this section. Then clause 3 says, in any case falling under clause C of subsection 2, which is where the registered trademark is identical and the goods or services are also identical, the court shall presume. तो यहाँ पे shall presumption है that it is likely to cause confusion on the part of the public. इसका मतलब आपको प्रूव करने की जरूरत नहीं है एंड द कोर्ट शैल प्रिज्यूम कि अगर इन्फ्रिंजर ने ये मार्क यूज किया विच इज आइडेंटिकल टू द रजिस्टर्ड ट्रेडमार्क, तो इट विल कॉज कंफ्यूजन टू द पब्लिक. And fourth says, a registered trademark is infringed by a person who, not being a registered proprietor or a person using by way of permitted use, uses in the course of trade a mark which is identical with or similar to the registered trademark and is used in relation to goods or services which are not similar to those which the trademark is registered. And the registered trademark has a reputation in India, and the use of the mark without due cause takes unfair advantage of or is detrimental to the distinctive character or repute of the registered trademark. Clause 4 में well known trademarks की बात हो रही है. There are three things. A says that the trademark should be identical with or similar to the registered trademark. Then second, it is used in relation to goods or services which are not similar to those. हमने clause 1 में देखा था कि जो goods और services हैं they should be similar to the registered trademark. लेकिन यहाँ पे ये कह रहे हैं कि they may not be similar. Let's understand this with an example. तो अगर हम HP को लें, HP मेक्स लैपटॉप्स. अगर एक और कंपनी आती है एंड दे यूजेस HP's trademark and start making water bottles. This is the trademark of HP, which makes laptops. And a water bottle company started using this trademark on its own bottles. ठीक है. So just for the sake of example, we can agree that HP is a well-known company in India. It has a reputation in India. It has acquired a distinctive character. It is a registered trademark which has a reputation in India, and the use of the mark. तो ये जो bottle company है, it is using this mark without due cause, and it takes unfair advantage of or is detrimental to the distinctive character or repute of the registered trademark. तो अगर कोई वाटर बॉटल कंपनी HP को यूज़ करेगी अपने फॉर सेलिंग इट्स ओन प्रोडक्ट्स, राइट, so it would be detrimental to the laptop company and it would be infringement of its rights. So in such case you can file a suit under this section. Coming to clause 5, it says a registered trademark is infringed by a person if he uses such registered trademark as his trade name or part of his trade name or name of his business concern or part of the name or his business concern dealing in goods or services in respect of which the trademark is registered. Similarly, there are other types of infringements given under clause 6, 7, 8, 9. You can go through them. So the clause 1 of section 29 is a general clause which tells about what is infringement of registered trademarks. And clause 2 to 9 are different types of infringement that can happen and the ways it can happen. So key elements of infringement are: there has to be a similarity or identity of the marks, there has to be identity of goods or services, and there has to be a likelihood of confusion among the public. We read about the provision for well-known trademark under section 29. Under section 30, exceptions are given like fair use, comparative advertising, use in descriptive sense. Let's see section 30. Section 30, limits on effects of registered trademark. It says nothing in section 29 shall be construed as preventing the use of a registered trademark by any person for the purpose of identifying goods or services as those of proprietor, provided the use A is in accordance with the honest practices in industrial and commercial matters and is not such as to take unfair advantage or be detrimental to the distinctive character or repute of the trademark. Let's take an example. If I start selling ink and I write on a ink bottle that this ink is specifically for pilot pens, it can't be used for other pens. Okay, so if it is true that that ink is a special ink which can only be used for pilot pens, और अगर मैंने उस ink को किसी और पेन में डाला तो वो पेन खराब हो जाएगा, ठीक है, then it's fine, I can use it. It is covered under the exceptions. I'm not trying to use the reputation of pilot pens to sell my own ink. Okay, but if it's not true, if that ink is a generic ink and it can be used by any kind of ink pen, then I'm trying to use the reputation of pilot pens. So, which is not right and it would be a dishonest practice. Then I'm trying to use the reputation of pilot pens to sell my own product, and that is a dishonest practice and would not be covered under the exception. Next is consequences of trademark infringement. So we have studied what is infringement, what are the exceptions to it. लेकिन अगर आपका जो ट्रेडमार्क राइट है वो इन्फ्रिंज हो गया है तो उसके बाद आपके पास रेमेडीज़ क्या है, तो वो दे रखी है. देयर आर टू टाइप्स ऑफ रेमेडीज़. फर्स्ट इज द सिविल रेमेडीज़ which is injunction, it could be temporary or permanent, damages or accounts of profit, delivery of infringing goods for destruction, and then there are criminal remedies like fines and imprisonment, search and seizure of the infringing goods. Next is a case study of Starbucks Coffee versus Sardar Baksh Coffee and Company. So in 2018, Starbucks Corporation filed a lawsuit against Sardar Baksh in Delhi High Court. आपको नाम से ही समझ में आ रहा होगा कि दैट दे साउंड वेरी सिमिलर, देयर इज अ फोनेटिक सिमिलैरिटी. So Starbucks, which is a globally recognized coffee brand, it alleged that Starbucks' name and logo were deceptively similar to its own, leading to trademark infringement. The key issues were, firstly, the name and logo were confusingly similar to its own, which was potentially misleading the customers. Then the logo similarity. Let's look at the logos. These are the logos. So as you can see, this is the Starbucks coffee logo, which has a virgin lady with a crown, and this is the Starbucks coffee, which has a Sardar. So they do look a bit similar, and the brand name pronunciation. The name Starbucks and Sardarbucks sounded similar, which could cause confusion among the customers. So the Delhi High Court ruled in favor of Starbucks, ordering Sardarbucks to change its name and logo. Sardarbucks was directed to rebrand as Sardar G. Bucks Coffee and Company for its new outlets. The court found that the similarities in the names and logos could indeed mislead customers and infringe on Starbucks' trademark rights. Passing off. It is a common law tort used to enforce unregistered trademark rights. The passing of action depends upon the simple principle that nobody has any right to represent his goods as the goods of somebody else. This was held in the case of ICC Development International Limited versus RV Enterprises. अभी तक हम इन्फ्रिंचमेंट की बात कर रहे थे अंडर द ट्रेडमार्क एक्ट कि अगर यू हैव अ रजिस्टर्ड ट्रेडमार्क और आपके उस राइट को कोई इन्फ्रिंच करता है देन यू हैव सर्टेन रेमेडीज अंडर द एक्ट. लेकिन अगर आपका ट्रेडमार्क रजिस्टर्ड नहीं है तो भी आपके पास रेमेडी है अंडर द एक्शन ऑफ पासिंग ऑफ. So under the action of passing off, the main consideration is that whether the deception or confusion is likely to arise. इसके कुछ key elements हैं which you need to prove. First is goodwill in the market. कि जो आपका mark है, it has a reputation, it has a goodwill in the market. Second, misrepresentation leading to deception. कि जो दूसरा mark है, which is trying to pass off as your own mark, he is doing a misrepresentation which is leading to deception among the consumers. Third, it is damaging your goodwill. Action of passing off में जो damages होते हैं, they are claimed as unliquidated damages because it is difficult to identify what kind of damages have occurred. If we talk about the legal provisions of passing off, then it is a common law principle and it is not defined under the Trademark Act, but it is recognized and enforced by courts through various case laws and judgments. It has been recognized. Passing of action में जो burden of proof है वो plaintiff पे होता है. Plaintiff को तीन चीजें prove करनी होगी. First, that he has a goodwill in the market. Second, a misrepresentation has occurred which has caused deception. Third, that misrepresentation has caused damage to the goodwill of the plaintiff. Next, there is a case study of Cadila Healthcare Limited versus Cadila Pharmaceutical Limited. So, the Honorable Supreme Court held that the following factors need to be considered in case of an action of passing off of an unregistered trademark for deciding the question of deceptive similarity. Firstly, the nature of the marks. That is whether the marks or the word marks or label marks or composite marks, that is both word and label marks. Secondly, the degree of resemblance between the marks phonetically similar and hence similar in idea, as we saw Sardarji Baksh and Sardar Baksh. Third, the nature of goods in respect of which they are used as trademarks. नेचर ऑफ गुड्स में हम ये देखते हैं कि वो अंडर किस किस कैटेगरी दे हैव बीन क्लासिफाइड, इफ दे आर ऑफ द सेम नेचर और नॉट. फोर्थ, द सिमिलैरिटी इन नेचर, character and performance of goods of the rival traders. Fifth, the class of purchasers who are likely to buy the goods bearing the marks they are likely to exercise in purchasing or using the goods. Sixth, the mode of purchasing the goods or purchasing orders for the goods. Seventh, any other surrounding circumstances which may be relevant to the extent of dissimilarity between the competing marks. Differences between infringement and passing off. The trademark infringement is applicable to registered trademark. On the other hand, passing off is applicable to both registered and unregistered trademarks. Infringement is a statutory remedy under the Trademark Act, under Section 29, while passing off is based on common law principles. Under infringement, plaintiff is only required to establish that infringing mark is deceptively similar to the registered mark in respect of similar goods or services, and no further proof is required afterwards, and there is a presumption of confusion. While in the passing of action, plaintiff is not only required to establish the deceptive similarity of the two contesting marks, but also required to prove deception or confusion among public and likelihood of injury to the plaintiff's goodwill. पासिंग ऑफ एक्शन में आपको डैमेजेस भी शो करने होते हैं कि कैसे उस मिसरिप्रेजेंटेशन से आपकी गुडविल को डैमेज हुआ है, लेकिन ऐसा आपको इन्फ्रिंजमेंट के केस में नहीं करना होता है बिकॉज देयर इज ऑलरेडी अ शैल प्रिजम्पशन देयर दैट इट वुड कॉज अ कंफ्यूजन अमंग द पब्लिक. Next, let's talk about the remedies. So, for both infringement and passing off, there are two types of remedies: civil remedies and criminal remedies. And it is the option for the plaintiff कि उसको किस में अपनी proceedings initiate करनी है. आप सिर्फ सिविल में जा सकते हैं, क्रिमिनल में, या फिर दोनों रेमेडीज को अवेल कर सकते हैं. So under civil remedies, you can file a suit for infringement or passing off under section 134. You can file a suit in the district court where the plaintiff's head office is situated or where the cause of action arises. It is applicable to both registered and unregistered trademarks. Then relief under section 135, you can have damages or account of profits. Court may award these based on the plaintiff's request. Or you can have delivery up of infringing goods for the purpose of destruction or erasure of infringing labels and marks. Next, there is a remedy of injunction under section 135 clause 2. So it could be ex parte or interlocutory injunction, which could be temporary or permanent injunction. जो इंजंक्शन के प्रोविजंस हैं वो दे रखे हैं अंडर ऑर्डर 39 रूल 12 ऑफ सीपीसी एंड अंडर सेक्शन 36 to 42 ऑफ द स्पेशल रिलीफ एक्ट. The Honorable Delhi High Court, in the case of Louis Vuitton versus Agarwal, 2011, it issued a John Doe order along with the Anton Pillar order, permitting and allowing the aggrieved to conduct raids over a period of 1 month for tracing counterfeit Louis Vuitton products and goods. Such an act would enable imprisonment of each party dealing with counterfeit. John Doe orders court तब इशू करता है when they don't know who the defendant is. आपने मार्केट में देखा होगा बहुत काउंटरफिट प्रोडक्ट्स बिक रहे होते हैं, जैसे कि एडिडास शूज विच इज़ अ काउंटरफिट ऑफ एडिडास, राइट. तो ऐसे लोकल शॉप्स पे फेरी वाले इस तरह के काउंटरफिट प्रोडक्ट्स बेच रहे होते हैं. तो ऐसे केस में बहुत मुश्किल होता है ये पता करना कि कौन कौन डिपेंडेंट्स और रिस्पोंडेंट्स होंगे जो कि इन्फ्रिंज कर रहे हैं रजिस्टर्ड ट्रेडमार्क को. तो ऐसे केसेस में जो कोर्ट है वो एक जनरल जॉन डो ऑर्डर पास करता है अगेंस्ट ऑल द डिपेंडेंट्स हु आर इन्फ्रिंजिंग द right of the trademark holder. Similarly, Anton Pillar order is issued. It is issued for search and seizure of the premises of the defendants, जहाँ पे वो counterfeit products store किए गए हैं. तो पुलिस वहाँ पे जाके उन products को collect करती है for the purpose of evidence. Court can issue other kinds of orders like discovery of documents, preserving infringing goods, restricting disposal of assets. Then there are criminal remedies. So under section 102, for falsification of trademark, if there is an unauthorized use of trademark or making it deceptively similar, then there is a penalty under section 103. You can have an imprisonment for 6 months to 3 years and a fine of rupees 50,000 to 2 lakhs rupees. Under section 104, there is a penalty for aiding the offender. Then there are second and subsequent offences given under section 105. Then if there are second or subsequent offences, then the punishment is given under section 105. Higher penalty is given for repeat offenders. There is imprisonment of 1 to 3 years and a fine up to 2 lakh rupees. under section 111, forfeiture of goods is given. So court may direct the forfeiture of goods involved in the offence. So there is a dual approach to it, that plaintiff can seek both civil and criminal remedies. So as a trademark holder, you have all these civil and criminal remedies to protect your trademark. But it is very important to be vigilant and take proactive legal actions. अगर आपने अपने ट्रेडमार्क को रजिस्टर करा रखा है, then you have remedies under the act. And you can directly file a suit under section 29 and avail all those remedies. लेकिन अगर आपने अपने ट्रेडमार्क को रजिस्टर नहीं कर रखा है, then it is very difficult to file a passing of action and prove that you have a reputation and your reputation has been damaged by the infringement of your mark. So it is very important to register your trademark timely and then be vigilant if someone is infringing your trademark right.